the post-hearing participation gap and order implementation. One of the greatest misconceptions about family court is the belief that the final hearing represents the end of conflict. That once the order is made, safety returns, clarity returns, structure returns, and the survivor can finally move forward. But for many survivors of coercive control, domestic abuse, and litigation abuse, the hearing is not the end. The order is not the end. It is simply the transition into a new phase of control. Because the reality is this: many participation protections effectively end the moment the hearing closes. And what follows is often ambiguity, enforcement barriers, procedural loopholes, vague drafting, institutional silence, and continued manipulation through the order itself. So in today's masterclass, we examine the post-hearing participation gap, the dangerous space between obtaining an order and actually being protected by it. This is Masterclass 5, the post-hearing participation gap and order implementation. I'm Samantha, your host. This is Silent Screams, Loud Strength, Unmasking Justice. The myth of finality, it is a myth of finality, because when you have gone through control, coercive control, financial control, the family court culture often treats the order as closure, clean break. The hearing ends, the decision is made, the files move forward, life for your oppressor begins to thrive. But coercive control rarely operates according to the procedural timelines. For many survivors, the order itself becomes another arena where control continues. Because coercive control is adaptive. When direct control weakens, procedural control emerges. The abuse evolves through interpretation, delay, ambiguity, technicality, non-compliance, and institutional fatigue. This is why many survivors of domestic abuse describe a strange emotional collapse after proceedings end. Not relief, but confusion, because they realize the existence of an order and the reality of protection are not always the same thing. The problem of vague drafting is that one of the most serious safeguarding failures within family proceedings is the vague drafting, the ambiguity, the wording that creates procedural gaps. And procedural gaps create opportunities for continued coercive control. For example, an unclear handover arrangement identified communication boundaries, vague financial ambiguity timelines, unclear implementations, responsibilities, or imprecise safeguarding conditions. To a survivor, these gaps may appear small. To a cohesively controlling individual, they become operational openings and opportunities, because coercive control thrives in ambiguity. If wording allows multiple interpretations, the survivor may find themselves constantly defending interpretation, constantly clarifying meaning, constantly returning to court, or constantly exposed to renewed conflict. This is why drafting patterns matters the most and matters deeply, especially for survivors. So poor drafted orders do not merely create inconveniences, they can create recreated instability, uncertainty. There is no healing, there is no closure, there is no finality. So procedural loopholes as control. Many survivors discover that litigation does not end after a judgment is issued. It mutates, it manifests into something else. The post-hearing phase may involve delayed compliance, repeated reinterpretations, partial implementations, strategic confusions, procedural obstructions, financial delays, or repeated technical disputes. This creates what I call procedural looping. So the survivor becomes trapped in clarification, enforcement, follow-ups, hearings, administrative exhaustion, and constant vigilance. Again, the nervous system never fully exists. The survival mode is constantly switched on, and importantly, many survivors no longer have legal representation or never had it. Emotional capacity diminishes, financial resources are depleted at this stage. The system assumes a resolution has been reached, but the survivor may still be living inside ongoing procedural control, and the abuser thrives in this. The enforcement gap. So this is when a court order only functions if enforcement is accessible, and this is where many survivors encounter institutional abandonment, because obtaining an order and enforcing an order are very different realities. The survivor may face delays, high thresholds, procedural complexities, evidential burdens, financial barriers, or institutional reluctance to intervene. This creates a dangerous contradiction. The court may recognize harm during proceedings, but become procedurally distant once implementation problems emerge. So, and this matters because coercive control often escalates precisely during transitions. Coercive control is accumulative. So separation, handovers, financial division, property transfers, and post-order implementations. When you're dealing with someone who is redundant in the sense that they do not want to follow procedure because they are always right, this is where survivors frequently remain vulnerable. And vulnerability equals nervous system shutdown. So the participation collapse after hearing. And another hidden issue is this. Many survivors psychologically collapse after hearing concludes. Their body goes into a real deep shutdown. During litigation, survival mode sustains function. Adrenaline sustains movement. But once the hearing ends, the nervous system crashes. This may present as exhaustion, emotional numbness, cognitive shutdown, anxiety, depression, disassociation, or inability to continue engaging administratively. And yet, post-order implementation often requires organization, follow-up, enforcement applications, communication, evidence gathering, and procedural vigilance. This creates a devastating contradiction. The point at which the survivor is most psychologically depleted is often the point at which the system expects them to self-manage, implement, be proactive, active. This is one of the least understood safeguarding gaps in family proceedings. So, institutional silence after order is issued. Family proceedings often focus heavily on hearings, evidence, submissions, and judicial outcomes, but they very little think about the structural attention that is given to it, life after the order, and the human behind the order. What happens after the hearing, after the judge leaves, after the lawyers disengage, after procedural protections end? Many survivors report isolation, confusion, procedural abandonment, and lack of guidance. The system assumes the order speaks for itself, but vulnerable survivors may still be required or still require clarity, support, safeguarding, continuity, enforcement, guidance, and trauma-informed implementation in structures. Without that, continuity of participation rights effectively expire at the judgment. Once the order is out, participation rights have expired. Why precision matters. One of the most important lessons survivors and practitioners must understand is this: precision is not correction. The more precise the order, the more fewer interpretive gaps exist. The fewer procedural loopholes exist, and the less room remains for coercive manipulation. Orders should therefore be specific, structured, time-defined, operationally clear, and implementation-focused. Ambiguity benefits power. Clarity protects participation. This is not about hostility. It is about safeguarding through precision. Because coercive control frequently survives not through dramatic violations, but through technical manipulation. Coercive control is accumulative. They could be small acts, but directive needs to be precise. The order needs to be precise. The hearing is not always the end of coercive control. It's part of it. It's one of these jigsaw puzzles. So sometimes it is simple or simply the transition into procedural continuation, and the family justice must begin to realize or recognize this, that participation does not end at the judgment or at the issue of an order. Protection must continue through implementation, because an order that cannot be safely implemented is not fully protective. The law is precise and expressive. Therefore, ambiguity should not exist. A survivor remains trapped in an ambiguous enforcement barriers, procedural looping, and post-order intimidation has not truly existed if the architecture of control is still prevalent. This is why trauma-informed justice must evolve beyond hearing alone or hearings alone. It must address the implementation, the enforcement, the continuity, and the structural safeguarding after proceedings, after formal hearings are concluded. The full briefing must be precise to accommodate the human behind the whole process. Family law should always be precise. Family law should be about safeguarding domestic abuse victims. Policy reform needs to happen now. Thank you for listening. This was Participation Gap, a serious structural issue that needs addressing. This is Silent Screams, Loud Strength, Unmasking Justice.